Hello folks, welcome to the Edupedia world, and I am Abhinay Gupta. Today again we'll continue with the interesting topic that we were continuing with, that is the appointment and qualification of directors. We have already had 2 lectures on this topic, right, and today is the 3rd one. So what have we learned in the first 2 lectures? In the first lecture we had planned our work, right, and now we are working out our plan. So in the first lecture we had seen all the various topics and all the various things that you need to understand and that you will learn by the end of this chapter. And in the second lecture what we had covered is the need of a director for a company, the form of a company, right, and why can't a company operate on its own, and what is the need for a director, right? And then we have also understood the key difference between an executive director and a non-executive director, right? We have understood 2 terms very closely. Hanji? And today we'll move a step ahead, and in this lecture we'll cover that only an individual can be a director in a company, right? We cannot have a body corporate or something. And then we'll also see the maximum and the minimum number of directors that a company can have, right? Categorized into all types of companies. And then we'll also see the limitation on the number of directorship for a director, right? So let us start with the lecture today. So the first topic that we need to understand is the director's form, which is contained in the section 149 of the Companies Act 2013. So a director has to be of a single form, that is an individual, right? And why do we have directors as individual only? Because we can fix responsibility for that particular individual, right? Because the directorship is an office of trust and individuals can be held responsible, right? Take an example. If we have a body corporate as a director, and you have, for example, if you have a partnership firm as a director and you have 7 partners, right, and something goes wrong, whom do you blame? Whom do you hold responsible? Whom do you punish? Who bears the liability? Who bears all the penalties? Is it all the partners or any one of them? 6 of them worked very well. They had no problem. They were technically sound and they performed really great. But one of them made a blunder, and the penalty is lifetime imprisonment. Now, is it just to send all 6 of them or 7 of them to the jail? The answer is no. But otherwise you will not be able to fix the responsibility on any one of them. So for that particular purpose, the Act, the section 149 says that only individual can be directors. You cannot have body corporate to be director of any particular company, right? There's one more thing contained in section 166, that a director cannot assign his office, and this is a little typical topic. This 4-word, no assignment of office by a director, is a real typical topic. You have been asked questions on this topic in your past examination, right, referring to the case of the Orient Metal Pressing Private Limited versus B.K. Thakur. Now, with the help of this case study, right, with the help of this solved case in the year 1961, we'll try and understand what does no assignment of office by a director actually mean, right? So instead of taking the entire case in detail, right, we would try to go to the conclusion. We'll try to hold on to the main essence of the case, right? That will help us understand the meaning of the statement, no assignment of office, right? Instead of going in detail of what the company did and not, right? So what we will do is we'll try referring to our question that has been asked in CA final November examination in the year 1995, right? So I'll read out the question to you. The question actually was based on this specific case, the Orient Metal Pressing Private Limited versus B.K. Thakur. And B.K. Thakur is actually Bhaskar Kashinath Thakur, right? So first I'll read out the question that was asked in your examination. The question goes like this. X was appointed as a director for life by the Article of Association of a private company. So the article has appointed him director for life, right? And that was incorporated in June 2014. The article also empowered X to appoint a successor. So the appointment of successor was empowered by the article, right? X appointed by will G to succeed him after his death. Can G succeed X as a director after the death of X? This is what the institute wants you to reply on. Right? We have seen that the director is not allowed to assign his office. But over here the question says that article has given him the power to appoint a successor. Right? And G was appointed. Will G be able to hold office? Right? Will that be lawful? So now we'll understand the answer, and we'll also see how are we supposed to write the answer. I told you in the very first class we'll also discuss how you are supposed to write the answers, right? So first we'll understand the case and then I'll read out the answer to you. So in this case the director was empowered by the article to appoint a successor, and he appointed G to succeed him after his death, right? And as per the statement, the director is not allowed to assign his office. The word his is very, very important, right? As per the article, he is empowered to appoint some other person in the place of director after his death. So when he is died, the office is no more his, right? Because the prohibition applies to him only when he is a director. After his death, the office becomes vacant, and that cannot be assigned to any other person. And if you appoint a new person to that office, that does not result in assignment, right? That is the essence. You have to understand the difference between assignment and appointment. You assign your office, you are in office, you want someone else to take over your chair, you stand up and you ask that person to please sit on my chair and continue my responsibilities. That is assignment of office. But once you are dead and your will says that yeah, Mr. G will be holding your office, then that is not assignment. That is appointing Mr. G to your position, which is vacant now. So we are appointing Mr. G and not assigning, right? Understand the difference. You are still a director and then you give it away to somebody else, that is assignment. But now you're not a director, the seat is vacant. Now there is no assignment because there is no swap. Now if a person comes to that seat, he is appointed, right? So how do you write the answer? If I read out the text to you, then it is: no director shall assign his office to any other person. If it does, the assignment should be void. Section 166. Right? This is the first line of your answer that you should be writing. So, and then you will refer to the given case. You will jot down the entire case study as like the article has empowered him, right? And then he has assigned, appointed Mr. G. Once he has died, G is taking over the office. Now, is it valid? Yes, because it is not his office anymore, it is vacant. And then Mr. G is not assigned, he is appointed. And then you will refer to the case, the Orient Metal Pressing Private Limited versus B.K. Thakur, right? And then in the last paragraph you will write that the given case is similar to the case, resolved case of Orient Metal Pressing Company, and according to that the appointment of G is valid and it does not assign to assignment. Right? That is how you write the answer. So first you write down the provision, then you write down the story of what is given in the text, what is given in the question, what has the question asked. Demonstrate the entire scene, link it to the case study or the section, right? And then you say that as per the section and as per the given case, this is the conclusion. That is how you break your answer into. You have to write the entire provision first, then the case study given in the question, and then your conclusion. Right? If you write your answer this way, you score marks, and scoring marks in law is very easy because you most of the times know the answer. But the only place where you lag behind is scoring because of the answers. You're not able to write your answers well, right? So I hope that is very clear with you, the section 149 and 166. We move on to the next section, which is another subpart of section 149, the number of directors. Right? So what is the number of director? It is not a general term. You'll have to split it between three type of companies: public company, private company, and a one-person company. Right? So The minimum number of directors in a public company is 3. You cannot have less than 3 directors in a public company. You cannot start a public company with less than 3 directors, right? And if you want to start a private company, you will have to have a minimum of 2 directors. Only one person company is a kind of company where you have one director, one shareholder, one thing, because that is a one person company. The entire company is managed by one person. Why will you have a second director? Just for formality? The answer is no. Right? So you will not have a second director there. You will have only one director. And what is the maximum limit for these 3 companies? Are they also specifically mentioned different? The answer is no. You have a fixed limit for that. You have 15 each. So the maximum number of directors that any company can have is 15. No matter what kind of company it is. Right? And if at any point of time you want to raise the number of directors to more than 15, is it impossible? No, it is possible, but for that you will have to go to the shareholders now. That is beyond the power of the board. So as per the power of the board, 3 to 15, 2 to 15, 1 to 15 is the restriction. Right? And that can further be restricted by the article. In any particular private company, the article can restrict the number of directors to say 10 or 5 or 7. And then if you want to go beyond that, you will first have to amend your article, right, to go to the limit of 15. And if you want to cross that limit of 15 too, you will have to approach your shareholders. And the shareholders will pass a special resolution allowing the company to employ another director to cross the limit of 15 and go ahead to 16, 17, 18, whatever it is. Now, for example, there was a company X Limited that existed before the commencement of the Act, and they had 20 directors. Now what will they do? Because once the Act was applicable, the Act says that you can have a maximum of 15 directors only, but they have 20. What do? That company will now be given a time limit of 1 year from the commencement of the Act to bring it down to 15 by whatever mean you want. And if you want to keep more than 15, pass a special resolution, amend your article. All of those things have to be done, right? And so for doing any of these things, any of these tasks, either to appoint more directors or to bring it down to 15, you force some directors to vacate their office, whatever you do, whatever procedures you follow, you have a time period of 1 year to do that. So from the commencement of the Act to next 1 year, you will have to abide by the Act. And henceforth, this will be the limit, the minimum and the maximum. And now as per Companies Act 2013, you also have one more provision, that is that at least one of your directors should be an Indian resident. Right? And resident is again an important word. You need to understand that it is resident only if it stays in India for more than 182 days. Right? We have other definition of resident too. Right? So that is to be very precise with it, that you have to have one resident individual as a director. And there was a notification in the previous year on 5th June 2015, GSR, that was a notification, and then you had the series of numbers behind that. So as per that notification, section 149, the number of directors, will not be applicable on the company licensed under section 8. Now what are section 8 companies? The not-for-profit organizations. So those companies do not have these limitations of minimum and maximum directors. Right? This is a recent notification, maybe and may not be important for examination, right? But if institute wants to check you on the awareness and on the updation that you have, this can be a question in your coming examinations too. Right? It is a very recent amendment, it is a very recent notification. So that is all about the number of directors in a company. Right? And I hope it is very clear with you people. Right? Now we move on to the next section, which is section 165, the number of directorship. Now we have seen the limitation of a company holding the number of directors. But are the directors allowed to hold directorship in an n number of companies? The answer is no. You have a ceiling for them too. Right? So the maximum directorship in any public company is 10. You cannot be a director in more than 10 public company at one point of time. Yeah, you may be at different point of time, like you are a director of A, B, C, D, E, F, G, H, I and J company for the first year. The second year you leave D and G and join K and L, right? That is possible. Don't misunderstand this. 10 is not your lifetime limit, right? You can resign and join a new company, but at one point of time you cannot be a director in more than 10 companies, 10 public companies. Now you ask, yeah, if it is public company, then can I be director in an n number of private company, n number of NPOs, n number of government companies? The answer is no. For the totality, again you have a limit of 20 companies. Maximum 10 public company, not more than that, and overall you cannot exceed more than 20 companies for your directorship. That is the limit. Now, as per this section, the definition of public company would also include those private companies who have a holding company or a subsidiary company as a public company. Right? So if your holding or subsidiary is a public company, you will be considered to be a public company, a director of a public company for section 165. So it is not public company as per the literal meaning, right? You go into an interpretation, and if you're holding a subsidiary, any one of them as a public company, then that company is considered to be a public company, not a private company, right? And one more thing, in any particular company, the members may lower the limit. They cannot increase it, but they can lower the limit for their specific directors. Like if there is X Limited and it does not want its directors' involvement in more than 5-6 companies, it will set the maximum limit. Okay, you can be a director in 7 companies at max, because going beyond that hampers your attention in our company. So shareholders, let us pass a special resolution that our company directors cannot hold directorship in more than 7 companies. That will be your ceiling now. Understand? Now again we go back to the example that we have taken in the previous section, that if any company held more than the maximum number of directors, if any director held more than the maximum number of directorships before the commencement of the act, then what is he supposed to do? Does he have the same provision, rectified within 1 year? Is it so? The answer is yes. But here you have the procedure of rectifying it, right? First you'll have to choose which companies are the one that you need to continue, that you want to continue. Make a list of the companies. Yeah, these are the total number of companies where I am a director. Choose 20 companies and not more than 10 public companies, right? And then resign in the remaining unticked companies. And the day you forward your resignation, your involvement with the company is over. We consider you to have left that company the day you forward the resignation. You won't wait for its acceptance or something, right? So the effect of your resignation is that it shall become effective immediately on the dispatch of the resignation to the company concerned, right? And as per the provisions of the Act, no person will be continuing in those specified companies that you have unticked and for which you have dispatched the resignation, either after dispatching the resignation or after the period of 1 year from the commencement of the Act, whichever is first. For example, 1 year has lapsed and you have not yet dispatched the resignation, right? But you have crossed, you have chosen the company you want to continue with. So the other companies, you stand vacating the office from other companies automatically. Those offices stand vacated, right? And if before that you have forwarded a resignation, then that is the date from which it is vacant. Right? It is as simple as that. Whichever is earlier, either your resignation dispatch or the period of 1 year. And then once you have done all this, once you have done given all the resignations and choose the company that you have to continue, you will have to intimate the same to the company as well as to the registrar. Now, which registrar? Registrar of Delhi, Haryana, registrar of Mumbai, which registrar? Registrar of each such company where you are continuing as a director. If all of them are in Delhi, Haryana, all of them, just go to one registrar of Delhi and Haryana, that is a common registrar, you know. And if it is for more than one, if it is into the ambit of more than one registrar, go to all of them, right? So that is what you have to do. So that is all about section 165. We have done 3 topics today, and section 165 is one section, I must tell you, on which you have been asked questions in the year 2001 and also in the year 2008. Right? It has been asked in the gap of 7-8 years, and now again 7-8 years have lapsed. Maybe asked again, you never know, right? So that will be all for the day. This is Abhinay Gupta signing off.